to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Mission's Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Mission's Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Mission's Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Missions Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Missions Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Missions Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Missions Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates. Join Vinayaka Mission's Law School and become a part of a community dedicated to shaping the future of law and legal practice. Contact us now. Welcome to Vinayaka Mission's Law School, VMLS, Law School of the Future, an integral part of the pioneering and vibrant Vinayaka Missions Research Foundation, VMRF, deemed to be university. VMRF offers a multicultural experience where diversity thrives and enriches our educational environment. Vinayaka Missions Law School, approved by the UGC and the Bar Council of India, upholds the highest standards of legal education. VMLS is mentored by OP Jindal Global University and Jindal Global Law School under an institutional mentorship agreement. It is dedicated to foster inclusivity, imbibe excellence, and advance justice. VMLS offers a wide range of programs, including 5-year integrated law program and 3-year law program. At VMLS, we adapt legal education to industry changes. Our program equips students with knowledge, skills, and professionalism for today's world. VMLS is proud to have an esteemed mentoring committee comprising leading legal professionals who provide invaluable guidance and mentorship to our students. Our accomplished faculty members, composed of esteemed alumni of top national and international universities, ensures a comprehensive understanding of both local and global legal intricacies. We've partnered with renowned industries and law firms, providing students with real-world insights and enriching internship opportunities. Elevate your campus experience with our eco-friendly facilities, extensive sports options, and diverse hostel accommodations for both boys and girls. We believe in recognizing and rewarding deserving candidates.
May I now request Mr. Suresh Samuel, Member, Board of Management, VMLS, to welcome our distinguished guest, Honorable Dr. Justice S. Muralidhar, with a sapling. May I now request our Dean, Vinayaka Mission Law School, Dr. Anand Padmanabhan, to deliver the welcome address.
Good morning, everyone. To welcome the much respected, much adored Honorable Justice Dr. Muralidhar, retired Chief Justice of the Odisha High Court and Senior Advocate, Supreme Court of India, who graciously agreed to deliver the inaugural lecture for our Center for Justice through Technology. Mr. Anthony Julian, a very committed convener for the center and a practicing advocate in the Supreme Court and Madras High Court, who has generously given a lot of time for the cause of academia. My faculty colleagues, Professor Sinjini Sen and Gunjan Saxena, who serve as the coordinators for the center, and all our dignitaries here, and our wonderful students, colleagues, and everybody else. This is a great occasion, and I'm sure that we are a little short on time because we began a little late on account of the inclement weather. But while you wait with excitement to hear from Justice Muralidhar on digitization of courts, a subject on which he is truly an authority because of the tremendous work done under his institutional leadership, I would like to take the time to share a few words about our institution. Vinayaka Missions Law School, set up in 2021 as Arupade Veed Institute of Law, started its mission with one central question and exploring the answer to that. What would a law school set up for the future teach and do? And as we all know, questions have driven humankind often in very many interesting ways, such as why did the apple fall from the tree, or why can't rockets be reused? So when engaging with this very question of how would a law school for the future look like, we too started probing various possible answers. Of course, there were the very obvious ones: artificial intelligence and its impact on law, the risk of climate change and unsustainable growth and what that means for the world of law and policy, the new global order that we see around us and what that means for the field of human rights. But as we dug deeper, we decided that as an institution, we resolved that we are going to focus on one big challenge, which through all these transitions we are seeing as going to be a huge one, and is already a huge, massive challenge, which is that of inclusivity and diversity in access to education, and in our case, legal education. So we really started, thinking more deeply about this question. And thankfully, some of the initial work had been done by late Professor Shamnath Bashir, who rallied many of us in support of increasing diversity in legal education and access to justice through increasing diversity in legal education. As we got closer to that work, we realized that inclusivity is a very complex issue. It has, of course, certain things to do with class structures, monetary constraints, but it's far more than that. It is about diffidence. It is about perceived obstacles in your mind, whether it's language barriers, merit barriers that you see for yourself. So it is truly about, if you want to solve for that problem, it's truly about empowering the learner. It's truly about teaching people to learn to learn. So we really then, having realized this complexity of this problem, we started thinking about what can we do to find better answers to this problem. Of course, we are nowhere close to perfection. But we spent a lot of time really to dig deeper and to create structures within Vinayaka Mission's law school to address it. The very first of which is, of course, the mentorship agreement with Jindal Global Law School, one of the finest institutions in our country today. While we draw from all the work that Jindal has done in terms of creating a cutting-edge curriculum for the purpose of catching up with all these transitions and trends that I had mentioned above, we also innovate internally on the designing of the pedagogy to ensure that someone who thinks in Tamil can learn law in English. It is, of course, easier said than done, and we have seen very many challenges along the way, but that's also what makes our journey exciting as an institution. From the 4-decade-old VMRF institution, the management, which has lent its weight to this mission, to me and my faculty team, to all our colleagues at the institution and our students, we are here and working hard to create a unique legal education model and to co-create one. So we ask ourselves very many questions as part of this challenge. For instance, can technology come to the rescue? And this is where our centers of excellence play a huge role, and in particular, the center that we are inaugurating today, the Center for Justice Through Technology. Can we, for instance, use translation technologies to enhance access to knowledge and to improve conceptual clarity of law? Can we use smart classrooms in such a way that people from all across the globe, the best and the brightest, can come to our building virtually and provide education to our students? So these are just some of the questions that we raise, and as you can see, very many questions abound. Like I mentioned earlier, we are a work in progress as an institution, and we have a long way to go. Finally, I would just like to close out by leaving you some food for thought. The way you braved the weather or the weather alert and landed here today to engage with Justice Muralidhar and his work on digitization of courts, I hope all of you continue engaging with VMLS, supporting us in our mission to ensure that inclusive legal education is not only a pipe dream but a genuine reality. Thank you for your patience.
Julian, convener, steering Committee CJT to introduce the charter and vision of Center for Justice through Technology with all of us.
Honorable Dr. Justice Muralidhar, former Chief Justice of the Orissa High Court, students, my fellow members of the bar, I welcome you all today, and thank you, Sinchini, for the introduction. Technology, simply put, simply defined by ChatGPT no less, is the application of scientific knowledge for practical purposes. Legal tech has come a long way, from being seen as an eyesore in courts to now a cynosure. To quote the Chief Justice of India, Dr. D.Y. Chandrachud, it is part of the system like law books. It is like a driving license required for driving a car. Technology and legal practice have become more and more intertwined in the last 3 decades especially. To give you a very small example, let's look at the way cause lists are now distributed. Earlier, the lists used to be sent to each lawyer's home or offices the previous day evening. I remember as a young boy running to fetch the cause list from the post box in our home for my father. But now we've reached a time where the PDFs are uploaded onto the court website. And now we have apps which compile all the cause lists and also pick out which matters, which courts, which lists we have. And we're also at a stage where we can appear in all those matters remotely sitting in one office. So that's a good example of how technology can be used to make the existing system more efficient. You know, like adding grease to a wheel. Let's call that phase 1. We are now well into phase 2 of legal tech. That is at a phase where advances of technology have reached to such an extent that we can now change the way the legal system itself works. Simply explained, one good example of this is the Kleros protocol platform that I came across recently. So that's a very interesting system. It's basically a blockchain-based, anonymized arbitration, anonymized, decentralized arbitration mechanism where the platform has jurors who buy into the system by buying an Ethereum-based cryptocurrency. And when disputants upload their disputes to this platform, the system anonymizes all the data, but just crystallizes the dispute alone, and it sends it out to these 5 randomly appointed jurors who are again anonymized. So the disputants don't know who the jurors are, and the jurors don't know who the disputants are. And this is where it gets interesting. The jurors are rewarded by getting a return on the Bitcoin, on their cryptocurrency, only if they decide with the majority. So let's say an issue is framed that did person A breach the contract or not. So only if if 4 jurors decide one way and 1 juror decide the other way, only the 4 jurors who decided in the majority get a return on the PNK or the cryptocurrency that they put in. So when it's anonymized, and each of them don't know how the other person is going to decide, right? So this way, it incentivizes all of them to decide in a fair and judicious manner. So this is a very small example of how far legal tech has come. And the interesting thing about this is that an arbitral award passed by the system was not recently, I'd say guaranteed rights, interaction with local government, rights as citizens, all in the context of social justice, economic justice, and political justice. The CJT aims to be an incubator and an ideator of justice innovation, which is in keeping with the larger mission of VMLS and VMRF. Justice innovation can be loosely defined as the effort to create better and more effective tools, products, processes, services, technologies, and ideas of justice delivery that are accepted by markets, governments, and civil society. Towards that end, I can think of no better beginning than with an inaugural lecture by Justice Muralidhar. He has a unique distinction of being a doyen of the bar and the bench. In his efforts to digitize the judiciary, he effectively utilized technology not only to make the system lawyer-friendly, but also citizen-friendly. And at CJT, we are perfectly aligned with that sentiment. Thank you for patiently listening to me, and without much further ado, our keynote speaker.
Thank you, Anthony, for introducing the vision of Center for Justice through technology. Now is the moment to gain insight from our esteemed speaker, Honorable Dr. Justice S. Muralidhar, who stands as one of the finest judges in recent times in our country. Born on August 8, 1961, Honorable Dr. Justice Muralidhar earned his Bachelor of Science degree in chemistry from Vivekananda College, Chennai. Subsequently, he completed his law degree from the University of Madras, receiving the L.C. Miller Medals and the Carmichael and Ince Prize in 1984. His illustrious career spans almost 4 decades. He retired as the Chief Justice of Odisha High Court on August 7, 2023. Honorable Dr. Justice S. Muralidhar is our legal luminary, embodying a remarkable blend of intellect and empathy. During his tenure, he achieved significant milestones for the Odisha High Court, such as establishment of regional judicial academies, the monumental digitalization of records, and the widespread implementation of video conferencing facilities across every district in the state of Odisha. However, his impact transcends far beyond. Recognizing his exceptional qualities and legal acumen, the Honorable Supreme Court recently designated him as a senior advocate of the court. His legacy as a lawyer and academic is illustrious, marked by the attainment of a doctorate from Delhi University for his thesis on legal aid and criminal justice system in India. His book, Law, Poverty, and Legal Aid, Access to Criminal Justice, stands as a seminal contribution to the subject. He played pivotal role in important cases, served as the Election Commissioners Counsel during T.N. Sessions era, and held a part-time position as a member of the Law Commission of India. Without further ado, may I now request Honorable Dr. Justice S. Muralidhar to deliver the keynote address. And may I also request all the attendees to keep ready in writing if you have any question which will follow in the Q&A session. I will request the banquet manager to come and clear the stage and remove the chairs.
Good morning, everyone. While they still clear the table and chairs, I thought I'll make a few introductory remarks on today's lecture. First of all, I want to thank the Vinayaka Mission Law School for inviting me to deliver this lecture, and in particular, Mr. Anthony Julian, Dean Anant Padmanabhan, Assistant Professors Sinjini Sen and Gunjan Saxena. I'm also very happy to see some of my old friends here and distinguished members of the audience, and most of all the students who've come in large numbers. You'll be happy to know that this is one of the first presentations on the digitization in Orissa that's happening to a non-judicial audience. We've had it presented in conferences of judges, but never to a lay audience. And I'm very happy to share what has been happening in Orissa in the past 2.5 years since I took over as Chief Justice in January 2021. Many of them wonder whether all this could have been done in 2.5 years. The fact is that this is a work in progress. It definitely received a lot of fillip because of the kind of team that worked in Orissa. on these measures. It's never the work of one person. It's work of several people coming together, thinking alike, and wanting to share the common vision that they have for the judiciary. So with those introductory remarks, may I now proceed with my presentation. What I'm planning to do today is to give you a brief history of the digitization of courts in India. And it has a long history. It began, first slide. It began in 1989 when they used computers for caveat checking. Caveat, young law students may not know, caveat is something that you lodge in a court anticipating litigation against you. So for instance, in the first court, if A has won the case and B has lost the case, and B is likely to appeal against the verdict to the next court, A will lodge a caveat. Basically, A is telling the court, without hearing me, don't pass an order in B's appeal. So caveat checking was a big issue at that time, and the court took its baby steps, the judiciary took its baby steps in the Supreme Court of India in 1989. So we're talking of well over 3 decades. And then Karnataka took the lead in computerizing at the district level. The Planning Commission recognized computerization as part of the judicial infrastructure. And in 1997, which is, I think, 26 years now, the district courts, 430 district courts were computerized by the National Informatics Center, NIC, through funds received from the Ministry of Information Technology. In 1998, 27 district courts were computerized. When we say computerized, basically it was introducing machines into the court registry, not in the courts itself. We have what is called the back office of all courts, whether it's the Magistrates Court or the Supreme Court of India, people working behind the scenes to make sure the cases get listed before the court and work on those case files after the hearing is over and carry out a large number of steps to make the case progress. In 2003 and 4, there was a centrally sponsored scheme for judicial infrastructure which funded the computerization of 700 city courts in Delhi, Calcutta, Mumbai, and Chennai. All this you will notice is like a pilot. They were only experimenting at this stage, and like I said, many of the functions of the court were really not computerized. Maybe preparation of cause lists was, categorization of cases was, substituting typewriters with computers for word processing, probably that was happening, and not the full-fledged computerization that we are seeing today. So the first judicial action plan began in 2004 when a proposal was mooted for constituting what is called the E-Committee. Today we still have the E-Committee, which is headed by the CJI himself. And earlier it was headed by Justice Madan Lokur. And before that, I'll just take you through the history of the E-Committee as well. And there was a discussion on what should happen in the first action plan. So the first ever E-Committee was headed by Justice Bharuka, who was a retired judge of the High Court of Karnataka. Incidentally, his son, who's a senior lawyer, won the hackathon announced by the Supreme Court of India a year and some ago. So they prepared what is called a strategic plan for implementation of information communication technology in Indian judiciary. And this was discussed in the public domain, and they came up with this National Policy and Action Plan way back in August 2005. And this was supposed to last only for all of 5 years, but of course it went on beyond that. The idea was to have a complete coverage of all the steps from filing till execution of the decree through information communication technology. And the idea was to take the ownership of this whole program from the government into the judiciary. So basically the government would fund the program, but the running of the program would be by the judiciary itself. Very early on, they decided to go for what is called open source software, free and open source software, which was the Linux system. And it is my personal belief that this actually slowed down the adaptation of technology for judicial functioning in a very big way, because this was not compatible with many of the proprietary software which was being used in the public domain. If you all remember, Microsoft has a monopoly. So if you bought a computer, a laptop or a PC, the Microsoft Word program would be bundled with the machine. So you had no option but to buy it. Of course, much later, the antitrust measures happened in the US, but not with any success. Even today, they're trying to go after Google or Microsoft, but not with much success. The fact remains that Microsoft simply flooded the market. So most lawyers and most computer users were using the Microsoft Word program, whereas Linux was what the judiciary decided to go in for because it was free and open source software. I don't know whether that was the best thing to do at that point in time. I'm sure they were looking at budgets. Because it's a licensed software, and if you buy a license, it can only permit you to have so many users. In fact, all trademark lawyers here, I mean, the IPR lawyers here will know that much of the litigation in courts is about these giants coming and filing lawsuits saying somebody is using pirated software. Anyway, the point is that we persisted and we continue to persist with dependency on free and open source software, which I think certain courts did not go by, and those courts could therefore advance faster in computerization of their functions. In particular in Delhi, since I was a judge of the Delhi High Court for more than 14 years, and I was part of the computer committee in that court for more than 8 years, our adaptation of technology for our functioning was to a large measure because we did not use FOSs, but went for proprietary software. And very early on used Adobe, Nuance, and those kind of programs. And even for archiving of judicial records, we used the licensed software. So that helped us progress faster. And the second factor was that manpower, technical manpower. We were able to hire very good software experts to be part of the technology team of the Delhi High Court. And they helped write programs which helped us start off not only digitization, but e-filing. We didn't do online filing, but we had what is called electronic filing, which meant that somebody could bring in the petition in a pen drive, come to the kiosk set up in the Delhi High Court and file it through that kiosk, and it would get fed into the system in the Delhi High Court. This was I'm talking of more than 10 years ago. So Delhi High Court was one of the early courts not to go in for free and open source software. Today, Kerala also does not follow free and open source software. Kerala is a big leader now in computerization in courts, digitization of court functioning. I'll mention that a bit later. So the timeline that is interesting to follow is that the first phase action plan was launched in October 2005. But typically in the bureaucracy, there is time lag between sanctioning a plan and releasing the funds. And that explains to some measure the delay in meeting all these timelines. For instance, although the plan itself is approved in October 2005, the financial sanction is accorded only in February 2007. Today, this is still the problem in government not releasing the funds in good time, and you follow an April-March financial year, which means if the funds are released only in January, you can hardly be expected to spend it within 2 months in March, particularly since everything that you do in the judiciary, which follows the protocols of the government, has to be through a process of tendering, floating, inviting bids, floating tenders, and then not settling. If there's a single bidder, then you have to go for a fresh tender. So most of the money that is meant to be spent for judiciary does not get spent for reasons beyond the control of the judiciary. So this was the case in Orissa too, when I took over as Chief Justice. I'll just come to that in a minute. It was not till July 2007 that we could formally launch the e-courts project. under the first phase. And this therefore went beyond the timeline set, the 6-year timeline set for the completion of the phase 1, and went on till 2015. This was the phase during which laptops were distributed to all judicial officers. But as we all realized that those laptops were not bundled with the proprietary software, judicial officers were expected to use the Linux software and somehow teach themselves. There was no proper orientation or training given to the judicial officer as to how best to use the computer given to the judicial officer. As a result, what happened in the first phase was many judicial officers did not themselves use those laptops given to them. They would give it to their children or grandchildren, who would of course know how to use it. And in many an instance, I mean, this is not a one-off instance, in many an instance, those laptops in their nice boxes remained unopened. When we were having a conference in Vijayawada, I think it was in 2017 or 18, one of the judicial officers in Andhra Pradesh, I think it was Guntur district, got up to inform the whole audience that the computers that were supplied to his court in 2012 are still remaining unpacked. So it was a surprise to all of us, and he said, no, the technician who was supposed to come and install it never turned up. So judicial officers cannot be expected to be technicians, to be started to use equipment given to them on their own. And if something goes wrong, you don't know how to set it right. And this is true just not of computers and judicial officers, it's true of all of us today. We all grew up, at least I know, I grew up at an age when we still used to look at cars, open the bonnet and see a fan belt, see the dynamo, see the spark plug. If the engine didn't start, we would pull out the spark plug, use a sandpaper to get it done, and we had to tighten the fan belt along the dynamo. We knew how to set right some things that went wrong in the car. Today, the entire car is driven on a chip. So any car dealer today will tell you that the delays in supply of cars is because there are not enough chips available. And the entire chip manufacturing is dominated. The scene is dominated by just one country, which is Taiwan, which has the largest chip manufacturing facility. So today, it's become more and more complex. Basically, you are being controlled by technology rather than you being in control of technology. And this is a running theme of digitization in this country for many, many years. And since we are not leaders in either hardware or software, there's a great dependency on external agencies for these aspects. And this is a matter for concern that increasingly our lives are being governed by technology and by major players who are outside this country and who are not accountable at all to the governments of countries which are outside their own domain, and definitely not to the people of those countries. So this is again another running theme which we should bear in mind when we talk of digitization and adaptation of technology, not just for the judiciary, but in our lives in general. And today, so much of what we do is based on software that's not been developed in this country, based on hardware which is not manufactured in this country. So while we still say make in India, it is not that everything is made in India. They only import things which they assemble and sell it to us. So that phrase made in India really does not mean that every aspect of this phone, for instance, is made in India. Maybe nothing, no aspect of this phone is actually made in India, and all elements of this phone are probably assembled by importing, bringing into India the components and making it function as a phone. Well, that's the story of phase 1, and phase 2 was approved in July 2015. By the time phase 1 ended, some important changes did take place, and I'm going to focus on that in a minute. Now we are in phase 3. In September 2023, the phase 3 plan was approved, and the period for implementation of phase 3 is 2023 to 2027. What is interesting about this phase 3 document, the vision document, is that they've involved private players to drop the document. So you have private players. When I say private players, these could be non-governmental organization. And to just mention 3 of them, one is Vidhi, the other is Daksh, and the third is an organization called Agami. The document itself acknowledges that they played a very important role in putting together various elements of that document. I'll come in very soon to what this actually means for us in the judiciary. But today we are in phase 3 of the action plan. So the e-courts project as a whole, whether it's phase 1, 2 and 3, it envisages universal computerization of courts. That is from the smallest court in the hierarchy, smallest meaning in the judicial hierarchy, let's say the magistrates court, up to the Supreme Court of India, that all the aspects of the functioning of courts should be computerized. And one is, like I said, implementation is through free and open source software. There is also what is called a core and periphery model. What we've done is we've centralized this preparing the template and the software for implementation in courts by 2 or 3 agencies. One is CDAC in Pune, of course the NIC in Delhi. These are all government controlled bodies. NIC is part of the government itself. And they make what are called the core features of the plan. And other courts, particularly the high courts, are expected to develop the peripheral features. The problem is this, that in India, we have at least 26 high courts, and each high court has a different tradition. Just to give you an example, and this is basically for the law students here and not for the lawyers here, because they know all of this. In Delhi, if you file a writ petition, it will be called writ petition, and whether it's civil or criminal, we'll say bracket civil or criminal, and we'll give you the number. There will be a petition which is, let's say, 10 pages. It will be supported by an affidavit which is of 1 page. This is the model of the Delhi High Court petition. It mandates now a list of dates and a synopsis and all of that. If you come to Madras, the format changes. The petition will be a single page. The affidavit explaining the facts will be running to 10 pages. So it's actually a reversed format. In Delhi, they prepare what is called paper books. Basically, it will be like a small booklet like this, which is stitched up. In Madras, you'll have what are called bundles, which means you fold the paper across the spine. In Delhi, they've now switched to A4 size paper. In Madras, you can't fold an A4 size paper. Now you've switched on, okay. But you still fold the A4 like a bundle? Yes. So these are the small changes which occur from jurisdiction to jurisdiction. If you go to Gujarat, the writ petition will be called a special miscellaneous application. In Patna, it will be called something else. So the nomenclature from court to court changes, forms of affidavit from court to court changes, methods of listing of cases, methods of categorization of cases, all changes from court to court. One of the first tasks Justice Baruka, who was the first chairperson of the E-Committee, undertook was to try and standardize a single format for a writ petition, a single format for a plaint, a single format for a reply affidavit, and he was not successful. One feature of all of this I'm talking to you about is these measures of adapting technology for functioning of courts is driven by the courts. It's not driven by the lawyers. Lawyers are the major players in the court. Law clerks, that is munshis, persons who assist the lawyers, are another set of major players in the court. Now, they have not demanded these changes. They have not said, we want better functioning of our own offices, of our own courts, so let's go in for computerization. The push has come from the other end. The courts have said, let's organize ourselves more efficiently. Let's use technology for categorizing cases, for publishing cause lists, for listing of cases. So there has always, therefore, been a resistance to change from the bar and the law clerks. Today, as I speak, Kerala, I said, is a leader in digitization, as is Delhi, and as you will see is Orissa. But in Kerala, there has been a protest by the law clerks over the e-filing system that you have in the Kerala High Court, which is remarkably efficient. I don't know how many of you are aware of what's happening in Kerala. The law clerks feel that their role in getting cases filed, cured of defects, getting it registered and listed in court is getting minimized. They feel that in this new system, they will have no place. And the judiciary there is trying its best to convince them, no, they do have a role to play. So there is a resistance both from the bar and from the law clerks to these changes. One argument that the lawyers have put forth, and this was put forth in Orissa as well, and I'm sure it's put forth in Madras and other jurisdictions, is the digital divide. Just like in an audience like this, not all of us can be expected to afford a smartphone. Not all of us can be expected to afford a laptop or a PC. Many lawyers do not have the means to own a smartphone or a PC or a laptop. So such lawyers will justifiably ask, how am I supposed to adapt myself to this change brought about by the judiciary in making it mandatory for petitions to be e-filed? So one answer we found in Orissa is one, not to make it mandatory, to make it a very gradual process. If the lawyer is only able to present a hard copy of a petition, the court offers to scan it, digitize it for the lawyer, and give him a copy of the soft copy free of charge, so that there is no extra burden placed on the lawyer. Third, train the lawyers themselves, give them hands-on training, and not just train the lawyers, but train the law clerks as well. And fourth, to say that there will be no compulsion at all for you to switch over. If you feel that you do not have these devices, we are going to set up video conferencing cabins and e-kiosks and what are called e-seva kendras, where we will do all that we expect you to do for e-filing. You just give us the petition, we'll do the rest. So this kind of hand-holding is still happening in Orissa, and that is how we've been able to overcome the resistance by the bar and the law clerks to these measures that we've rolled out in Orissa. Just to continue with this, so in phase 2, the change was that the ownership of the entire program was with the judiciary itself. The E-Committee has become central player to rolling out all of these measures, and as I speak, we have e-filing version 4.0 which is ready but not yet rolled out by the E-Committee. And E-Committee now provides the policy planning, strategic direction and guidance. The role of the government, the central government here, we're talking of, when we say Department of Justice, the role of the central government has been limited to financial matters. Now I should pause here for a minute because people ask me, how is it it has been possible for you to do things in Orissa which we don't find in other states. One is just to, individuals do matter. Because I happen to be part, like I told you, of the computer committee of the Delhi High Court for over 8 years, and because I had an interest in adapting technology for my own work, even as a lawyer. I remember when the 286 computers came, 386, 486, some of us did take the early lead in bringing them into our offices and substituting typewriters and start using computers for word processing functions. So that curiosity about how technology can be used as a tool has remained. Not allowing technology to control what you do, but using that as a tool. So in the Delhi High Court, in the computer committee, I was very fortunate to be able to work first with Justice Madan Lokur, who was then heading the computer committee of the Delhi High Court, and then for several years thereafter with Justice Badr Ahmed. Now these are persons who have an interest in knowing the latest cutting edge technology. But Justice Badr Ahmed actually is a person who, as a lawyer, wrote software programs. So he was far ahead of the pack. So when we would sit for a computer committee meeting and the computer section would tell us, sir, we need so many PCs, he would be able to tell them which specifications will work, which will not. He will, if you show him a VGA card, he'll say, no, this is not the version of the VGA card we want for this function. We need a higher version. If we show him a laptop with USB portals, he will say, what is the version of this USB portal? Is it 2.0, is it 3.0? So the man was on the ball. He was an excellent judge, could do a wide range of matters, deliver brilliant judgments, but he was also technologically savvy. So I think the Indian judiciary has been very fortunate to have technologically savvy judges who have not shied away from learning. Yesterday, I spoke to the students. I said, learning is a lifelong mission, but learning not just about the law, learning about life. So even when we're dealing with issues concerning technology, we must know how the technology works. A good patent lawyer will tell you, if it's about a metallurgical process, I should know that entire process. If it's about making a pharmaceutical drug, I should know that entire process. I should know what is a molecule. I should know what is an pharmaceutical ingredient. I should know those technical details. That is the real role of the lawyer, is to get into the other disciplines and know the nuances of the other discipline. Your mind must be open to that. And that can only happen by extensive reading, wide reading. We say laterality in reading, right? Not reading narrowly focused on just what is necessary for your case, but reading a wide range of things. Only then the mind grows. So I was fortunate to be able to work with judges who had this kind of a mind, who were curious to know what is the best in technology and what are the dangers of using technology if you do not know the limits of the use of technology. So what we could do in Delhi was to introduce the first paperless court. For any paperless court, the first step is digitizing the paper, scanning the paper. But scanning the paper in the way that you can use it just the way as you would use hard paper, right? So typically in a petition, you would have a cover page, you would have a contents page. Lawyers will use the word index. People in the literary world will always wonder, how can you call this page of contents an index page? But that's how lawyers call it. Anyway, so there'll be a contents page, and then there'll be what is called pagination. So all of these we replicated digitally in the Delhi High Court. We sat with the programmers and we made them do it. We used proprietary software to what is called bookmarking the file. And bookmarking literally means flagging different pages for different, like the petition begins at page 8, the reply begins at page 52, the rejoinder begins at page 63. So if you click on the page number, it should take you to that page. It's like a hyperlinking. So this bookmarking also, we used proprietary software, and we therefore started making soft copies of petitions which were already filed in court, and that was the first step to having a paperless court. So in a paperless court, you would have a monitor which has the cause list for the day, which has the list of cases. If you clicked on the case number, the case file would open up. So you would store the soft copies of the cases in a common server, and you would be able to access the file through that server. So the court master or the reader, whatever you call him, for the judge, would do that task of pulling out cases from the server, assembling it for the judge, and making sure that when the judge clicks on it, the case opens up, and it's in a readable format, the format I've told you about. All of this happened perhaps for the first time in India in the Delhi High Court. And that experience did help me a lot in replicating this exercise in Orissa. But there are other things that have happened in Orissa which have not happened elsewhere, which we will talk about. So this is how from one learning you can progress to the next level of learning, but you must have the aptitude for those changes. If you're resistant to change, this progress cannot be made. Just like in many other spheres. I use the example of a car. Okay, a brand new car is parked in your garage. It's the latest model. Unless you get into the car and drive it, you can't enjoy that car, right? Otherwise, every Ayudha Puja, you can break a pumpkin in front of the car, have lemon placed under the tires, put tilak all over the car, and keep it closed in the garage. Likewise, with all these devices, computers, you have to take the plunge. You may make mistakes, you may trip and fall, but you will learn. Likewise, as far as training is concerned, when these mobile phones came, none of us complained that we have not been given tutorials. None of us said, unless you send me to a class and give me coaching for 1 month, I will not use this mobile. Today, I'll call one of these students. I'll tell him, here is an Apple i15. Will he say yes or no? He'll grab it, right? Even if he does not know how to operate that i15, he will still grab it. Because he wants to hold the best phone, the most expensive phone in the market, he wants to possess it. And he will teach himself to use it. When the touch phones came, many of us actually had a problem. You would press letter A on that electronic keypad and it will go and press something else. We all still make all those spelling mistakes with our smudgy fingers, trying to tap, because this whole thing of Steve Jobs was probably had children in mind with nimble fingers. which is why even a 2-year-old today is able to use this device far easier than you're able to, because it's made for that kind of a addiction. It's supposed to get people hooked on from their second year or third year, all digital devices. Anyway, that's a different debate altogether. What I'm trying to say is, people do take to new technology when it serves their purpose. So I give this example to the staff in the High Court. I give this example to the lawyers in the High Court, saying when it came to these mobile phones, none of us raised a protest. We didn't go on the street saying, oh, this mobile phone is so difficult to use, I want only landline, I don't want a mobile. Nobody said that. And mobile, nobody taught you. So today, even the persons who have not had formal education are able to use mobiles quite easily, and they don't complain. It's just the mind. So which is why we say it's changing the mindset to be able to overcome this inner resistance we have to using these new methods of organizing ourselves. Phase 3, we plan, this is what the E-Committee has planned, to consolidate all the measures that have been put in place and store data on cloud servers, and big data mining, which is a matter for great concern because judiciary holds very sensitive data of a large number of people with their most private problems being expressed in those petitions, the soft copies of which are held by our courts. So we have to be extraordinarily careful with the data that we hold, and we should not allow it for big data mining at all. So this is one concern. I'll come back to that. And of course, now there's a talk of artificial intelligence. How many of you know what happened at Bletchley Park yesterday? Have you heard the word Bletchley Park? Bletchley Park. Bletchley Park. Okay, this is a place where the government of UK is hosting a major international conference on artificial intelligence. And yesterday there was a conversation that took place between Elon Musk. Anyone heard of the name Elon Musk? Okay. See how quickly you were able to relate to that. Elon Musk and Rishi Sunak. You've heard the word Rishi Sunak, her name Rishi Sunak? So they've had a conversation in which Elon Musk is supposed to have said, among several other things, that AI is going to replace human labor. And that is his real fear. Of course, he tried to soften it, saying, no, I believe AI will be used for very positive things too. But he has that lurking fear that it will ultimately make humans redundant. And he says, I don't know what will happen to society if we go on this way. So this is something which an Elon Musk is telling us. And because we take Elon Musk so seriously these days, even if he changes the name of Twitter to X, we don't mind, we don't protest, we don't go on hunger strike, we don't go on the streets. We allow an Elon Musk sitting in California to control all our lives, to have in his servers all our most private data, no problem. And his servers are not in India. His servers are all outside of even US. They're probably in Siberia and Australia and New Zealand. We don't even know that. It holds all our sensitive data. We are very readily sharing our photos, my vacation photo, my birthday photo, my grandchild's birthday's photo, everything. So, and all Elon Musk has in his computers. So this is where we are, the kind of world. So these are the kind of persons who become the most powerful players. So when he says AI is going to replace work, it's something that we should all definitely be alarmed about. I thought I should just flag that for this audience because it's happening right now. Today's breaking news is that. And the other part of the news, today's newspaper, I have the old bad habit of reading newspapers, as some of us in my generation do. Today's Times of India carries a very interesting piece in the business page about Mr. Chandrasekhar, who happens to be the Minister for Information Technology, saying that we should not demonize AI because it can actually be very useful. So I think you should have both these news items next to each other and reflect on what is meant when two people, one in the government and one who's heading a multinational, telling us quite contrary things. You would expect governments to be worried because governments have no control over this technology at all. And governments are happily, sharing platforms with these powerful players. Rishi Sunak considers it's a big catch that Elon Musk has come to that conference and is having a conversation. So, even in our country, if Elon Musk has called you to his office, then it's a great thing. Even if you happen to be the president or prime minister of a country. If Bill Gates is talking to you, you welcome him with open arms. So this is our embracing of these powerful multinationals who are controlling our lives in big ways and who are not going to part with the software source codes. They're not going to part with this technology at all, and they are going to keep charging us. Worse still, they're going to make us all part of a big world, a virtual world, where we have no control of our own information. So what happens is systems get to know more about us than we know. So this is something that we all have to sit and think about. Anyway, so just to get back to the topic, at the end of phase 1, these were the goalposts that is not yet achieved. At that phase 1 ended, I told you, in 2015. We had still not had delivery of all the services by all the courts. We did not have automation of the case workflow. We did not have use of computers by all important sections of the registry, particularly, like I told you, the back offices. Those were not digitized. Those were not working in an automated form. We did not have a unified case information system. CIS is Case Information System for all courts. Even today, as I speak, while we have Case Information System 2.0 for the district courts, we still have CIS 1.0 for the high courts. And there are some high courts which have not got onto the CIS platform, and some of the major high courts have not got onto it, like Delhi and Bombay. They've still not got onto the CIS platform. What is a case information system? Basically, it assembles all the statistics concerning pendency of cases, categories of cases that are pending, orders passed in those cases, the next dates of those cases. So today we have what is called the National Judicial Data Grid. Have you heard of it? NJDG? Okay. This is definitely an important achievement at the end of phase 1, where these were all the goalposts that we still yet to achieve in 2015. I've mentioned all of this only because when I speak about Orissa, you'll know how far we've been able to achieve many of these goalposts. The milestones. So we have a CIS, not for all courts, I should clarify that, it's for all district courts. And we have automation of case workflow. We've put in place the software, but adaptation of that software for actual functioning of the courts is still taking time. We have the automation of administrative workflow, that is, we have softwares given to us, but we have to tweak those softwares. In Orissa, we found that we had to have a separate software altogether for this workflow automation. I'll speak about it later. Because all of these are based on open source software, they have their limitations. And also because the peculiarities of courts, like Bombay High Court arranges its cases differently from the Madras High Court, which arranges it differently from the Delhi High Court. And likewise at the level of the district judiciary, the courts organize themselves differently. It's difficult to have one program written for all the courts. We have now all these softwares available, but they need to be adapted for our use. End step, for instance, service of summons. In fact, one person asked me, are we able to achieve this? That is, you give the bailiff or the process server a mobile phone. This has happened. In this end step program, each process server is given a mobile phone, and which is a smartphone. So the process server goes to the door. If he finds it locked, he'll take a photograph of it. If he's serving some person, he'll take a photograph of that. He'll upload it onto a server. That will come into the court, and that becomes the process server's report. So today it's possible for you to have an electronic process server report. This is very similar to the tracking report for speed post services that we have, or the courier services that we have. So today, even in the judiciary, it's possible to know that a summons has been served. But students of the law should know that when we say service of summons, it means just not the notice from the court. It has to be accompanied with a petition in which the person is arrayed as a party. Now, just the summons without the petition is no service. That is enough case law for that. Again, the entire petition should be there. What usually happens in the physical world is the summons is put on top of the petition. The entire thing is put into a cover, which is then sealed. So I hand over the cover to the process server. The process server has no ways of knowing what is written in that petition, which is inside the seal cover, and he only delivers that seal cover to you. Electronically, where we come across a problem is that although the summons can be served electronically, This petition that has to accompany has to go only as an email attachment, right? Even if you protect it with a password, you'll have to share that password with someone. Let's say Mr. Anthony does not have a mobile phone, right? And he's sitting in some village, and he has to be served this petition. He does not have a device. He insists that I need a hard copy. Who's going to deliver that hard copy to him? That's the question. And if I print it out, as a postmaster, as a postman in my post office, I print out the petition in which Anthony is the respondent, privacy is lost, right? Things are written about Anthony which Anthony doesn't want the whole world to know. So how do we protect this? So this is where we have a slight issue, where we've not been able to find a solution for this last mile, where along with the summons, a petition has to go which can be read only by the recipient and no one else. So that is something that is a huge challenge for us. We manage this e-payment rather well. So today you can use your cards, you can use your RTGS, you can use all kinds of online payments for paying court fees. These facilities are available not just in the High Court, but all the district courts in Orissa. We have virtual courts in many of the districts in Orissa. I'm going to talk about that. We have automated emails. A hearing happens, the lawyer's email is available, an email is automatically generated. An SMS is automatically generated. Many lawyers sitting in the audience are already onto all those systems. They're getting updates on the cases when the next date is fixed for the case. Orissa has 30 districts. I just wanted to give you the spread, the geographical spread. I'm going to run through some of these things, what we've done in Orissa. We've had hybrid hearings because of COVID. Those hybrid hearings are continuing. And hybrid hearings not just in the High Court, but in every district court. Today you can appear in any district court in Orissa sitting in Chennai. No difficulty at all. The judge will hear you, pass an order. You can apply for a copy of the order, get the copy of the order. No difficulty. We have provided e-libraries to all the district court complexes. And wherever there are bar associations which have more than 50 members, we've provided e-libraries. A typical e-library will have 2 kiosks. It will have a free subscription for SEC Online for 2 years, for Manupatra and the local journal. So even in the smallest bar association, those lawyers who are serious-minded, want to know more about the law, can use these devices, even if they don't own a library and they can't afford one. Likewise, we have live streaming that all of you are aware of. We have e-Seva Kendras, we have e-notification systems, we have an e-custody certificate. This is the 9 months which was there in Punjab. I noticed that Haryana has developed an excellent system of an e-custody. Basically, when a bail application is filed, one of the first things the judge wants to know is the past criminal record of the person before him. How many cases is this person involved? Has he served sentence in any of the cases which have concluded in an acquittal and in a conviction? And how often has he come out on parole? You know, has he obeyed the conditions of an interim bail or a parole? So all these details are available at the touch of a button in Haryana, because they've beautifully integrated their system and they're able to access that information on the touch of a button. So we adapted that system for Orissa, and today, at least in 4 major prisons in Orissa, those inmates, their information about them can be accessed through e-custody certificates, which is available to the judge on the very first day of hearing of the bail application. So you don't need to adjourn the bail application for these details. So this is something that we found useful to adapt in Orissa. The last thing is something that I inaugurated on 7th August, on the date of my retirement. Orissa High Court is the only High Court that has a PIL portal, where it gives you information on all the major PILs. It gives you all the orders in the PIL. It gives you the links to the live streaming hearings of those PILs. If there are committee reports, expert committee reports in any of the PILs, that is also made available. So this is something I think we've taken the lead on in Orissa, and I'm hoping this will be replicated definitely with the Supreme Court of India and other high courts as well. So how you can use technology. During the hearings in Orissa, I was able to get real-time videos of what is happening on the ground. For instance, one of the issues was about shrimp farming, illegal shrimp farming in Orissa. I would have ordered the removal of a shrimp farm, and the petitioner's side would be complaining that my order has not been complied with. So once I had the petitioner's side lawyer arrange to have the local population there show us in the court in real time that that shrimp farm had not been demolished, although it had been asked to be, the illegal shrimp farm had been asked to be demolished. So in the court, once you have a live, visual, real-time visual, arguments are reduced. The government lawyer is not saying, oh, I'll take instructions, maybe this is not correct, let me file an affidavit, give me 4 weeks' time. All that is immediately eliminated. Then I'm able to tell the collector who's sitting in his cabin, he's sitting in wherever he is, he's watching the proceedings. I'm telling the collector, are you able to see this visual? He says, yes. Then I'm able to tell him, listen, you have to send your people tomorrow morning to demolish it. He says, I will. I said, now you have to upload a video on the next date. So I call the case after 3 days, I make the collector show me that he's actually removed the shrimp farm. All this using technology. Once there was an issue of, there was a slum colony in Cuttack where they had relocated some of the dwellers, and they were complaining of unsanitary conditions in the slums. So the Cuttack Municipal Corporation was given directions to clear up all the mess, the garbage, to provide mobile toilets, to provide all the basic facilities. And same thing, after 2 weeks when the orders were supposed to be complied with, the Petitioners' Council complained. So the Municipal Corporation Council was very vehement. He said, no, it has been complied with. What he's saying is not true at all. I said, very simple, tomorrow morning we'll list it at 10:30. Ask 2 of the Municipal Corporation engineers to be in there in that locality and let them just walk through the locality with their mobile phones, nothing more. That's what happened. At 10:30 in the morning, the 2 engineers walked through the slum. We were watching it in court. Walking through the slum, it was very evident that the garbage had been piled up and not removed. So no arguments. Then shamefacedly, that lawyer for the corporation said, I will comply with in the next 2 days. So it just cut through all this unnecessary thing of counter affidavit, rejoinder, dispute this, dispute that. You have said some falsehood in this affidavit. So you can use technology constructively, even in court hearings. This is what was an eye-opener for me. And very often I have felt as a lawyer, as a PIL lawyer, that if the court went to the site, see, I don't know if many of you are aware, in CPC and CRPC, there are provisions that permit the trial judge to visit the site. Let's say A and B are having a trouble with a boundary for their respective properties. Somebody is saying he's built a wall into my territory, whereas the wall should have stopped there. The judge, of course, today we appoint commissioners, court commissioners, advocate commissioners who file a report. But the judge herself or himself can actually go to the spot and physically verify if this is true or not. There's a provision in the CPC for that. Likewise, CRPC, scene of crime. Suppose the judge wants to understand how the crime actually occurred and through that location, because the scene of crime is a sketch map drawn by the investigating officer, which may not be clear. So the CRPC talks of the judge going to the spot and getting first-hand information on the scene of crime. Likewise, High Court judges should be able to do. Suppose I'm saying that there is some situation of demolition, forced eviction, or whatever. I wonder what would happen if the judges are able to physically go to the scene and see for themselves what is happening. Today, technology permits you to visit that scene, not physically but virtually. And I think people should take advantage. I want lawyers to take advantage of this technologically enabled court to present facts in a more realistic way, instead of depending on what is said in an affidavit, which is then contested, and there's endless exchange of affidavits and petitions and contempt petitions, which bring no solution to the problem. I'm just going to break here for a minute to show you a video on the functioning of the RRDC and then the paperless courts. Basically, the RRDC is a record room digitization center of the Orissa High Court. This was a building which was meant for an administrative tribunal, which got abolished. So when I took over as Chief Justice, they were going to return this building to the government, saying that now that the tribunal has been abolished, let's give this building back. And I said, no, I have excellent use for it. There were 11 lakh disposed of records in the Orissa High Court. And there were 2.5 lakh pending cases. If you walked into a branch in Orissa High Court, and I can probably show you a slide for that, how you would sorry. Tap on it. Just go to that PowerPoint. Caps lock பண்ணிட்டு PowerPoint. PowerPoint. இதுலயே PowerPoint போங்க ப்ளீஸ். ஒரு நிமிஷம். Now this is இது காமிக்க மாட்டேங்குது. க்ளோஸ் பண்ணுறா. இது எனக்கு காமிக்கணும் இதை ஸ்க்ரீனில். இது காமிக்கணும். வேறு எதை காமிச்சிட்டு இருக்கு. இது வெளில வந்துருங்க. மூடாதீங்க, இதை காமிக்கணும். Table, files in the chair, there'll be files in the floor. You'll find people standing up and working. And this was no different. It's the same whether it's Bombay, Calcutta, Madras. These record rooms are overflowing with paper. So one of the first steps was to ease the registry of the paper so that they can work better. So we had to move something like 11 lakh files into a building. And this is a slightly longish video, but it will give you the necessary break of listening to my own voice endlessly. So just watch this.
Record Room Digitization Center, where around 275 people, including High Court staffs, DEOs, scanning agency, and retired High Court staffs, are working for digitization of all disposed of civil and criminal records, and to essentially reduce the burden of storage of paper files in the High Court of Odisha. There are various stages which leads to digitization of disposed of records and finally to its shredding. Stage 1. Transportation of consigned records to RRDC. Disposed of civil and criminal records are kept in decree disposal and criminal disposal section respectively of the High Court of Odisha. The superintendents of the disposal sections send requests to the Assistant Register Administration on a daily basis for transportation of consigned records to RRDC. A staff of the disposal section monitors the process of transportation.
In the initial stage, 11 lakh records were shifted from the High Court to RRDC within a period of 2 months.
Stage 2. Receiving of records in the record room. Upon arrival of records in RRDC, the staff of the record rooms ensure immediate storage of the same in earmarked locations of the record room. The staff of record rooms check whether the record is complete in all aspects or not. The record room staff segregate the consigned records on the basis of date of disposal, and the bundles are then stored in ear-marked compactors chronologically, waiting for their turn to be digitized. Stage 3. Getting ready for scanning. Stacked bundles having case files are received from record room. Stage 4. Pre-process. Each file is assigned with a unique barcode for digital readability of the file. About 50 records makes a batch, and those batches are given a batch name for the work process of the scanning agency. Batches are sent chronologically as is received from respective record rooms. Stage 5. Ready for scanning. Files are made ready for scanning in the pre-process stage by removing pins, untangling, and checking its durability for scanning. Stage 6. Scanning. Files having barcode are scanned in high-speed automatic document feeder, or better known as ADF scanners or book scanners according to their condition. Paper passes through the scanner. Meanwhile, in the system, such scanned images get captured after each page is scanned. The ADFs take images of both sides and in a minute completes scanning of 60 pages or 120 images of both sides. Files are then stored in the racks. Stage 7. Quality check, QC. In this process, blank pages and folded pages are removed and rectified. Further, alignment of tilted pages, removing spots, and smoothing of edges and many such processes are carried out to improve the quality of the scanned record. Stage 8. Indexing. In indexing or bookmarking, each scanned page is flagged according to the nature of its contents, which would enhance its searchable quotient. Stage 9. PDF generation and OCR. Each scanned page is converted to PDF or portable document format. Optical character recognition (OCR) enables all case files to be converted into searchable PDFs. Each PDF file is separated as per the indexing parameter like order sheet, annexer, judgment, etc. And then multi-page PDF is generated. Stage 10. Post-process. After scanning, records are tagged and added with a cover sheet which has brief details of the records. Stage 11. Metadata entry. Name of the judge, year of the institution of the case, case type, name of the petitioner, name of the respondent, barcode and other important information is fed in the system. Stage 12. Verification of scanned case records by verifiers. The data of each physical file are verified with the soft copy to ensure whether every bit of information is captured in the soft copy or not. A total of 10 and 8 numbers of verifiers are engaged on behalf of the court to verify the accuracy of scanning and metadata entry in scanned civil and criminal records respectively. The said 18 verifiers comprising of DEOs and retired High Court employees constitute the first layer of verification of scanned case records. Each scanned case records are then checked page by page with regard to various aspects of quality of scanning such as visibility, readability, availability of each page, proper sequencing of pages, etc. Moreover, the verifier also has to verify and check as to whether the metadata entries made by the scanning agency are accurate and at par with the information contained in the physical case records. If the verified record is found to have any error, it is then sent back to the scanning team to fix the glitch. If the verified record is found to be error-free in all the above aspects, then the verifier has to put the date of verification and his or her signature on the cover sheet attached to each scanning record. This step denotes that the concerned scanned case record is successfully verified and is free from all errors.
After verification, the records are returned to the record rooms where the staffs check it and chronologically send it to the shredding office.
Stage 13. Final step of digitization process. To strengthen the process of verification, a second layer of random verification is being carried out by the judicial officers working at the registry. Once a batch of case is approved by the judicial officers conducting random verification, it becomes accessible for general viewing in DMS. The last stage, stage 14, shredding.
The shredding office works as a third layer of verification prior to shredding. After verifying the physical record, which tallies with the record in the DMS and ensuring that the aforementioned metadata are available in their scanned formats in DMS and are accessible and retrievable, the shredding office sends those records to the shredding room for shredding. The shredded files are thereafter auctioned out.
Thank you. It took a lot of hard work. We actually drew the entire flow, the diagram flow in the High Court during COVID. And we carried out in a hall in the High Court before we scaled it up. And all those minor glitches of what should follow what, how should people sit, everything was planned in the High Court on a smaller scale and then scaled up. I was asked whether we had some experts to advise us. The experts were my own judicial officers and me. So we actually did a trial and error, but COVID gave us that opportunity when the court load, work of judicial caseload was much lesser and we could focus on these things. I'll just go back to the presentation and then come back for showing you one more video. I'm going to talk now about the paperless courts. What is different from other states, other high courts, is that we have paperless courts in the districts. I'm just going to go straight. Just to mention this, we have digitization centers now in each of the districts. We started with 4 major towns, that is Berhampur, Baleshwar, Cuttack and Sambalpur in western Orissa. And we have 10 digitization hubs. Basically, in these hubs, we're covering all the remaining districts. And I was asked whether we're doing it for pending records also. We are. So not only are we scanning the old records, we're scanning the pending records, and we're making sure that when we receive records now, they're already scanned. So not only is the outflow of paper ensured, but the incoming paper is also scanned and received in soft form. The idea is that in about 5 years' time, there'll be no sight of paper anywhere in any of the courts in Orissa. So this will be a big achievement if it happens, and it's a matter of time. Because we are introducing e-filing, we are able to receive soft copies of petitions. And like I told you earlier, if a lawyer is not able to prepare a soft copy himself, the court steps in to do that. This is the VACAM monitor. This is my court itself. I basically watch the hybrid hearing that in the middle, this is the hybrid hearing monitor. These are the 2 monitors where me and my colleague have before us. The cause list appears on this, and I click on the case, and the case file opens, and we're able to conduct hearings. And this is combined with live streaming also. So this is one, and now I'm going to talk of paperless courts. So we began in 11 September 2021. Justice Lalit, who was the Chief Justice at that point in time, inaugurated it. We've got now 12 paperless courts in Orissa, in the High Court, and we have nearly 190 paperless courts in the districts. The vision is that by the end of 2024, every court in Orissa will become paperless. We've started with volunteers from the district judiciary. We asked judicial officers to volunteer to become a paperless court. Each paperless court has its own scanner, has its own system in place. We have a standard operating procedure for paperless courts. I'm just going to show you a small video on paperless courts, because videos explain to you far better than any other method.
Working of paperless court. India has a multi-level court system. There has been a high backlog of cases in Indian courts over the years as a result of the court's growing workload. A significant portion of the delay is attributed to the cumbersome paperwork that makes up the foundation of the court system. As the years pass, the case file accumulates with the petitions, memos, documents and their copies, citations of case laws, etc., making it increasingly difficult to organize and requires more manpower and storage space. Moreover, the handwritten order sheets and depositions fade away with passage of time, making them illegible and hard to decipher. An innovative concept of paperless courts has been envisioned and tested in the Apex Court and different high courts to address these issues and to provide speedy justice. In a traditional court, case information is available to a judge through a case information system. A paperless court, as the name suggests, is a court that functions without the physical records, where judges rely on digitized court records and use technology for facilitating the court proceedings. A paperless court strives to modernize the work process of the judiciary by eliminating the need for physical records and the inherent liabilities associated with the storage congestion, risk of misplacing and retrieving documents. In a paperless court, the entire case record is...
Yeah, so what you're seeing now is with the digital pen you can mark, you can highlight, you can underline. But this copy where you do all this will be stored in your server. So another judge who opens the file will open a clean file. So that's one advantage. There's also what is called a OneNote program, which opens, so you can divide your screen, you can read the petition on this side, and you can make your notes on the other side. So this is something that we...
available to a judge in a portable device, making it convenient to access the relevant part of the record without browsing through the entire file.
In the high courts, we also have the SEC online as part of this itself. So when the lawyer cites, I can just go to the SEC online and pull up the case and read it on the screen itself.
thereby saving time and making the workflow more efficient. It also reduces work pressure on court staff from organizing the record chronologically. The process of digitization involves sending of case records as per cause list, pre-scanning procedure, scanning of case records, quality check of scanned pages, metadata entry, bookmarking of scanned pages.
So basically what we had successfully done in the RRDC, we were just replicating it across Orissa in each of the district courts. No compromise on any of those steps that you saw, the 12, 13 steps on verification, checking the data and all of that. I'm just skipping through because of paucity of time. We'll just
mode, and their signatures can be obtained digitally, obviating the requirement of
So this is another question that comes up. How do we mark documents? How do we sign on documents? So this is the answer we found.
paper depositions. In paperless courts, it is very convenient for judges to have easy access to the bulky case records, which are segregated in different parts, and the relevant portions are available with a click on the bookmark. The touch screen devices enable the judges to take down notes and highlight portions of the pleadings and evidence found to be relevant during the course of arguments, which are of tremendous use while preparing orders or judgments. Judicial officers in Odisha have been given subscription of SCC Online. Now, in the paperless court, they can access the same on the Wacom right on the dais, which will help them in referring to the decisions of the Honorable Supreme Court and High Court. In the first phase of e-courts project, we had CIS, through which we could get the certain information of the case at the click of a button, and now, through the paperless court, since the whole record is digitized, the entire case record will be available literally at our fingertips. A paperless court which is not only economical but also environment friendly.
So one thing I wanted to mention is my understanding was every new batch of judicial officers, since they're all young officers, would want to immediately take to this because they all are comfortable using devices. To my surprise, I found some of the older judicial officers taking it to it very well. Likewise with lawyers. In Punjab and Haryana, 85-year-old Sikh lawyer would come with an iPad and argue from the iPad. So it all depends on the mindset. It all depends from individual to individual. An elderly person may take to it, a young person may be resistant to it. The idea is there should be no compulsion. So it is spreading slowly. Suppose I'm using a paperless court and Anant is not. Anant will watch me and learn, right? When I keep telling him, listen, it's so easy to use, he'll be tempted to use. It's just like how we did with the mobile phones. We kept watching the other person, or we asked our son, or we asked our grandchild, how to use, and we learned it from them. So the learning in this digital world is from the younger person. The older learns from the younger. It is an inversion of learning, but it has to happen. And that's how we can use much of this technology for our own benefit. So paperless court was a major thing that has happened in Orissa in the districts, which has not happened in other states yet. And I'm sure it will pick up. Kerala is trying to do it, and Kerala might achieve it very soon. The other thing which I'm very proud of is the Center for Judicial Archives. One incidental benefit of digitizing records, particularly old records, that we came across records which were 200 years old in Orissa, the oldest record being of 1808. And those records were extremely fragile but extremely valuable. So we had to adopt a different process for that. And I'm going to show you about the Center for Judicial Archives, and after that maybe take you to the question and answer session. All these are things that you have in other courts as well, nothing unique to Orissa, the e-inspection center, the e-payment of court fees, uploading digitally signed orders and judgments, the e-LCR system, lower court record. Many high courts have in their record rooms records of the lower court as well. And the trial cannot progress in the lower court as long as the record is stuck in the high court. So we cleared the High Court of Orissa of all low court records by digitizing it and sending back the lower court record with another additional soft copy for the judge. We mandated that no trial court judge will ever send a hard copy to the High Court, will only send a scanned copy. So if a record is called from the trial court, the judge is mandated to scan it there itself and send only the soft copy. This way we cut through a whole range of delays of old cases not getting disposed of because the matter is stuck in the High Court. Hybrid hearings I've talked about. Virtual courts is something different. There are two kinds of virtual courts. This virtual court is where the judge examines witnesses virtually. It could be a police witness, it could be a official witness who has just carried, let's say, a sample of a drug from the scene to the lab. And it could be a forensic expert, it could be a doctor in a hospital. They can slot different times. This is actually happening in Orissa. In these virtual courts, there's one in every district. They're able to slot. So the doctor doesn't come to the court and wait for days on end, or the whole day is wasted when he should actually be in the hospital looking at patients. So we're able to achieve this slotting of, just like they do abroad, so that no time is wasted. The entire proceedings happens virtually. So these are the virtual courts. We also have virtual centers of the High Court. We have 2 of the High Court staff go to each of the districts to set up these virtual centers. Basically, through e-filing, a petition is filed in the High Court of Orissa. In virtual mode, mentioning is made of the matter. Even defect checking, curing happens virtually. Mentioning is made virtually. Matter gets listed, you appear before the High Court. You see these benches. This is the High Court judge listening to the matter, and these are the district court lawyers arguing before the High Court. After the hearing is concluded, application for a copy of the order is done virtually. It is delivered, the signature, this digitally signed order is delivered in the district virtually. So nobody has to move from the district to argue, to file, argue, and complete a case in the High Court of Orissa. And this has been a solution for demand for benches. Before I went, every year there used to be strike from at least 4 or 5 districts saying there should be a bench of the High Court there. And this completely solved that problem, where we said, why 5 benches? We'll give you 30 benches. So that is what has happened, and it has, of course, displeased some, it has pleased some, but we are not here to only please people. We are here to see that the system functions. The system is more efficient, and the system serves the litigant. Just imagine traveling 800 kilometers from Western Orissa to Cuttack to engage a lawyer, to stay in Cuttack, to get the case filed, every hearing travel to Cuttack. All that is completely avoided, where you can conduct a case from wherever you are in any corner of Orissa. One happy fallout, and this is the vulnerable witness deposition centers. These are modeled on what happens abroad, particularly victims of sexual violence, child witnesses. They can be examined in these rooms, in these centers, without having to face the perpetrator. Very often the prospect of facing the criminal is what puts fear into the witness, and the witness is kept in a separate room. The accused can watch the witness, but need not face physically the witness, and this is something that we have done pursuant to Supreme Court orders. There is one now in every district in Orissa. I've already spoken about the e-libraries. We have case law portals, live streaming, of course, I've spoken about. I'll just talk about this conservation of fragile records. I'll just show you a video on that, and maybe after that we'll take the questions and answers. This is the only state in the entire country that has such a center for judicial archives, and which has a judicial history project going, and you'll know why.
All disposed of records of the High Court of Orissa are now being preserved in Record Room Digitization Center. With the help of INTACT, the preservation work is progressing at a rapid pace. The degradation of paper material depends on the quality of the paper and various other inherent and external factors. Among the most noticeable deterioration that is recognized during the course of this examination are the following: acidic and brittle pages, tears, cuts and losses, stains. damaged spines, creases and folds, softening of paper, previous insect attack damage, damaged binding, stuck folios or pages, bleeding or smudging of ink or color. Unless treated in time, this deterioration could reach such a stage when a large part of the collection could be lost forever. Conservation procedure, documentation of the record, dry brushing of individual record, chemical and physical examination of record, fumigation of records or pages. The records are fumigated for at least a week inside fumigation chamber with appropriate fumigants like paradichlorobenzene and thymol crystals. Chemical conservation, consolidation and fixing of running inks. Aqueous deacidification in case of sheets having non-soluble inks. Double-sided lining with good quality tissue papers to impart physical strength to the record when they are in extremely fragile condition. Stitching and binding of the guarded and lined sheets with conservation guidelines. These conservation interventions, when carried out on a fragile record, enhances the lifespan of the record when preserved in controlled climate, and technical guidance. For purpose of exclusive plan, the High Court of Orissa proposed a separate building on a land adjacent to RRDC.
I'll skip over this. This is a building that's coming up now. It should be ready by January next year, where we will be scanning all the district court records, not just the high court records. The historians are delighted that they will finally have access. We're going to put this as an open source. All these digitized records will be available on the website. So any history, any person interested in legal history can access this from anywhere. And it's going to be a very valuable resource for a historian. And we had the first National Judicial History Conference in Orissa in May this year, where the historians came and addressed us and gave us useful suggestions on how we should go forward on this. So I think I've covered most of what I wanted to say. There are, of course, some challenges I have spoken about in briefly earlier in my remarks. I think I'll cover some of them in the question and answers. So thank you for your patient listening. Thank you. Just to end up what you saw, so this is how the record room in Cuttack was, and that's how it is now. And this is how the registry actually looks now. This is the transformation in Orissa. So the employees themselves can't believe what's happened. This is how a listing branch now looks, what you see on the right. So that explains the video many of you saw when the employees gave me a farewell. So it only showed me this, that when you work as a team, when you work with people who share your vision, much can be achieved with the existing resources. So just remember that it's not about lack of resources, but it's a lack of will that really matters. Thank you. Thank you. Do you have questions? Yeah, anyone with any questions? Yes, please. Just give him the mic then.
Sir, that was a great learning for me. I come from a non-legal background.
Right.
And also have a limited IT knowledge though.
Yes.
And I can see the phenomenal effort that has gone into.
Right.
I think this would translate to one of a global case study, given the demography of India and the quantum and volume of files that you have done digitized. I think nowhere in the world, I think, to this volume. I don't know. Probably that is something that, because I used to work for different verticals globally, and legal as a vertical had a very limited IT intervention. And this phenomenal work that has been done probably can go into a global case study. That is a comment that I would like to make. The second thing is, I think this digital knowledge is very imperative to have integrated to the law students. Though there could be a self-teaching which can be triggered with all these youngsters, but I think the overall thing, not only in terms of understanding, but also in terms of keeping themselves abreast of all the new technologies. You started with AI, and what Elon Musk said and what Minister Rajiv Chandrasekhar said. I think, see, these kids also need to be brought into that particular digital knowledge orientation. So how this need to be integrated in our curriculum and pedagogy?
No, I think there are enough material now. Just the 3 action plans, that itself can form part of the material. There are articles written on how far these action plans have succeeded or failed.
Okay.
And there's enough material on that.
Okay.
And actually field trips. I must tell you all that Orissa High Court has opened itself to public visits. So every weekend there are public visits by members of the public with our staff taking them around the whole court. But we also invite students to visit the court premises and also see the RRDC and the Center for Judicial Archives. So I think even field visits can be organized. Orissa will be only too happy for people to visit these facilities. And there is, I must tell you that even Madras High Court has a digitization center. So it's worth visiting and getting to know how that whole thing works. So there's enough for at least a credit course for students.
So the E-committee has given targets, sir, to different states in terms of completing
That's
something
right.
like this?
But like I said, the development across India is uneven. One, because of the lack of judges who share the same vision. See, much depends on the Chief Justice of a High Court. Okay, if the Chief Justice prioritizes this, much can get done. If the Chief Justice has only 2 months' time or 3 months' time, we've seen Chief Justices for 1 day, we're Chief Justices for 1 week. What can that Chief Justice plan? They can't even begin to do anything. So I got lucky there. I got 2.5 years in Orissa. Second, support of the state government. I had immense support, but for which I had to demonstrate that I know how to spend. If I'm scared, if the budget for IT is 600 crores and I'm very scared to spend that 600 crores, then nobody can help me. So I should know how to spend it, how well to spend it. Then if you have given me 600 crores and I'm showing you how well I've spent it, you will be encouraged to give me more. If I give you back 400 crores not having known how to spend it, you will not give me more money, right? That's how the whole system works. So the more efficient you get, the more trust you build, and the more trust you build, the more support you will get. So it's a cyclical thing. So these are 2 very, very important. Third is orientation for this. Not all judges are technologically savvy. Not all judges can themselves come up with ideas. It's just hit or miss that somebody who's not averse to technology is in a given time in the IT committee or something like that, or a Chief Justice of a High Court. But we do need technical support, exclusive technical support just for the judiciary. Today what is happening is NIC sends small teams to various high courts. There is no exclusive company or a corporation or entity that's looking only into the needs of the judiciary. In Orissa, we've been able to set up what is called the Judicial Infrastructure Management Agency, which is a department within the government, which deals only with infrastructure projects of the judiciary. And we have a computer corporation of Orissa, which is helping us procure software and hardware. But not all states will have these kind of facilities. So that also explains why it's not uniform across the
I'll just wind up with one last question. Since you touched upon the funds, we saw the benefit, the efficiency, the productivity this can yield. Have you done any cost benefit for?
No, we've not actually done down to that. There is some cost benefit that's been happening.
Okay.
But I can confidently say that in the longer run
Yes, sir.
is when you'll actually get to see the real benefit, not in the shorter run.
Thank you, sir. Thank you for enlightening us.
Giridhar wants to, yeah.
I think everybody in this room is amazed at the work done, and I'll be echoing their sentiments. And all of us are very happy that we attended this session. We did know that a lot of good work has been done, but not to this scale. I just have one question. How did you manage to put together all these experts and, quite a bit of range of talent and expertise was involved? How did you put them all together?
I think choosing the people, one of the lessons in management is, if you're in a position of a CEO or a managing director or, heading an organization, you must know which are the horses for the courses. So as a Chief Justice, you still have to know, forget technology. Let's say I should know which among my judges is good for the bail roster. I should know which is good for the second appeal roster, who's good for the writ roster. I should know my judges. So likewise, I should know my technical team. So I handpicked. I interact with them on a very personal level. I know what their outlook is, their abilities are, and you actually have to, even agencies, they're also looking for some feedback. So I enter the building at 9:15 in the morning. I start walking around, and I've given each of them a task. At 9:45, everybody sits on my table, and I follow up on, what is the achievement on each task. So if that kind of follow-up is done, then you do get results. And if somebody's stuck somewhere, then you have to suggest how they can get out of it. But this requires a lot of personal involvement. And you must like what you're doing. So several factors. And that's why I think individuals can make a difference, and I think this demonstrates that.
Yeah, good afternoon, sir. Myself, Ravi Chandran, correspondent and secretary of Nehru Memorial College. A perspective from the other side, I have been a litigant for the last 40 years. I've been fighting several cases, starting from the Municipal Court to the Supreme Court with SLPs and other things, mainly against the bureaucracy and governments and so many whatnot. In fact, even this morning I was telling my friend Samuel that when the system of calling is going to end in the courts in India, because we waste a lot of time in calling
out cases.
Cases.
Correct.
And you don't have the hearings happening. Most of the time is wasted in calling.
Because they're not planning. Or see,
Yes.
if I know I can take on only 20 cases, and there are 80 cases before me, I won't do even those 20 cases, right? Because I'm calling out these 80 cases, and mentally I'm tired by the time the 80th case is called out. So this requires a lot of planning at an individual level, judge-wise, and I have to be honest. If Giridhar disposes of, let's say, 80 cases a day, and I dispose of 10, doesn't mean I'm a bad judge and he's a good judge, right? It's about our relative strengths. So we should be conscious of that and plan our case accordingly. But because of the huge volume of cases and the lesser number of judges, we are just getting bogged down by numbers.
I understand, sir. So one more question, sir. Did you face any, in your course of implementation of this fantastic program, was there any political?
Not at all.
Not at all.
Not at all.
There was. What was the
I
political
think I
will
just
to
got-
support you?
No, yeah. I think you demonstrate efficiency. I had the Chief Secretary and Revenue Secretary of Orissa visit this RRTC 1 year after it was inaugurated. And they had only one question to ask. They said, we've been trying to do this for the last 10 years in Orissa. How did you manage?
Fantabulous work, sir. Congratulations.
I didn't mention one thing, the judicial workflow automation system. We got TCS to come and customize it for us. So today the office of the Chief Justice of Orissa is paperless. No waiting with files outside my chamber for 2 hours or 3 hours. I can operate the system even from my residence as a Chief Justice. So no file was pending with me for more than 5 minutes. So that changed the whole way things operated. Completely changed the way the High Court functioned.
So my name is Syed, work as IT head here. It's a fantastic story, and the involvement of technology in justice, what you had showcased. One quick question: with such a great successful story, does any other high courts have reached you to implement it, sir?
No, like Kerala is a very interesting case study. So Kerala's case study is right now happening. And again, we have some judges with vision there. Now, we don't know if that will continue after they move on. Like, I was apprehensive what might happen after my retirement. I'm happy to say that this is continued. Because we scaled it up to a level, and that is why time is important. I went at a breakneck speed in the first year of my Chief Justiceship, because I was never sure how long I'll continue in Orissa. And if I don't scale it up, I know that it will get quickly dismantled. It's just like, let's say X is the Chief Justice, and now Y succeeds him, and X and Y don't agree on many things. Most of Y's time will be spent on dismantling what X has done. And this is a story in many organizations, and judiciary is no exception to it. So we had to scale it up. Second, I had to get the rules changed. I didn't focus on that. The holding time for cases, because traditionally cases are supposed to be kept forever under the British times, never to be destroyed. The cover sheet itself will say. So all that changes with digitization. A digital record which is verified so many times, like you saw in this movie clip, that kind of verification means this is a solid record, an accessible, readable record, much better than the paper record. So we had to change the rules. We wrote into the rules all these changes. The standard operation procedure is now written into the rules, which means you have to do that extra effort. You have to send it to the government, get it notified, and all that has happened. So it is now, and I created a separate branch for this. There are registrar records now. And record room in any high court is a punishment posting. Not in Orissa, it's a plum posting.
Good afternoon, sir. I'm an advocate practicing in the Madras High Court and the lower courts. My name is Sanjesh. One question I had was, what were the challenges you faced, or rather, how receptive were the lower court staff in taking into account and implementing these processes? Because
so you have to convince them. I traveled to every one of the 30 districts. I organized hands-on training for advocates and their staff of the courts. That was the first phase. And hands-on means somebody sits next to you, somebody teaches you how to hold the mouse and click. Because any amount of videos and circulating the videos doesn't amount to training. Frankly, I know that, like I told you with the car, you can keep watching videos on driving the car. You have to get behind that wheel and shift the gear. You have to drive. So the hands-on training proved a very useful thing, and they could see for themselves. And then peer learning happens. If that next table is doing it so well, why not I do it? That kind of a thing. So over a period of time, they've gone more and more receptive. They suddenly found the entire non-judicial branches of Orissa High Court are paperless now. We sent them for training in batches, but that alone was not enough. When they actually saw how easy it is to push a file from this table to that through the land system, it changed the whole outlook. Complete outlook.
So there was a lot of, I'd say, hands-on involvement from you, sir. That is what prompted this.
Yeah. And unrelenting. It has to be unrelenting. You can't give up.
Thank you, sir. I just have one question. The 14 steps that you mentioned were in RRDC where you were digitizing records. The 14th was shredding, if I remember correctly. So my question is, if on the off chance or in the event there's a mistake in scanning, or there's a software attack and you lose a lot of files since all of them are in a central server.
So we have 3 backups. I didn't tell you that. On hard drives, we have 3 backup. So, and what we are shredding right now, so a different protocol is followed for civil appeals and criminal appeals. There are some documents which can never be shredded. The IT Act schedule, if you look into it, a will, a conveyance deed, these can't be shredded at all. So we have to put them in bubble wrap covers. We all usually expect parties to come and take it back. But if a second appeal has been pending for 25 years, 30 years, that generation is gone, the next generation may not even be interested. So the ones we are shredding now are the bail applications, anticipatory bail and bail, writs, 482s. This is the bulk of our filing in our high courts. And these don't contain that kind of sensitive records, although we still check them for all those sensitive records and try and see if those sensitive records can be kept out of shredding. So there's no danger that way of something that can't be retrieved or can't be reconstructed. Even in the physical world, there are so many instances of files getting lost, correct? There's a fire. Jammu and Kashmir, there was a flood once. Jhelum went into flood. It flooded the entire basement of the High Court, the old building. Files were lost. In a fire, files have been lost. So you tell both the lawyers, this is all written into the rules of the High Court, you ask both lawyers to reconstruct the file. So those things will apply. But so far we've had no issues at all. This seems to be a more assured way of preserving a file than we imagined.
And perhaps on a more lighter note, which city do you think is better, so Delhi or Chennai?
Sorry?
On a lighter note, which city do you think is better, Delhi or Chennai? Since you've spent considerable
Which
city?
City?
Yeah.
Both has its own, both have their strengths, but Delhi is more toxic. In every sense of the word.
Sir, I'm Advocate Jacob Kurian. I've been practicing for the past 40 years in the Madras High Court. What you have shown us is like what we saw 40 years back in here is like we moved into a different space, into a different planet. And what you've done in the Madras High Court is, in the Orissa High Court, is amazing. In fact, I came thinking that I'll learn something about digitization of courts. But the ideas you gave are actually live. I mean, what you said about you can have a person live streaming. We had that a few days back when, for a contempt case in an IP matter, they said they had removed the trademarks and we said they had not. So as you said, affidavits were being filed. But if you can have a person go and show from the spot, so what you have said ignites our mind to hundreds of different possibilities. So I think that is something we should spread among our lawyers, because there's a million things which can be done to make things simpler.
In fact, it's become quite routine if something objectionable on the website, and I've asked the person to pull it down, and this other person says, no, it's still there. In the court, even in Delhi High Court, we used to do it. Immediately go and check it on the net with everyone watching. So
thank you, sir. It's an amazing job. It's wonderful.
Thank you all. So due to paucity of time, Justice Muralidhar also has a flight to catch. So thank you all for your interest. We'll now move on with the program.
Thank you. Thank you.
After a delightful discussion, may I now proceed with vote of thanks. On behalf of Center for Justice Through Technology and Vinayaka Mission Law School, Chennai, I extend our heartfelt gratitude to Honorable Dr. Justice S. Muralidhar for gracing us today and giving us your valuable time. I would like to express my heartfelt gratitude to Anthony Julian, Convener, Steering Committee of CJT, for not only providing right direction to CJT, but also ensuring success of this event. I would like to thank Dr. Anand Padmanabhan, Dean VMLS Chennai, for his constant dedicated efforts for bringing this event into light. I would like to extend our heartfelt gratitude to Dr. A.S. Ganeshan, Chancellor VMRF, Dr. Anuradha Ganeshan, Director VMRF, Dr. Francis Julian, Senior Advocate, Supreme Court of India and Chairperson Mentoring Committee, Mr. Suresh Samuel, Member, Board of Management, for their constant encouragement and support. Special thanks to our marketing team, admin team, who contributed their time and expertise to make this event memorable. The success of this event would not have been possible without the hard work of our dedicated organizing committee and Ms. Gunjan Saxena, faculty VMLS, and the support of our student volunteers. Thank you for your tireless efforts. To our esteemed audience, your presence has added immense value to this gathering, and we are grateful for your active participation. As we wrap up this event, let's carry the positive energy and insights gained today into our future endeavors. We look forward to your continued support. Let us all stand up for National Anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Once again, thank you all for making first CJT lecture a resounding success.